here, I should acknowledge, thank you. Both Judy and JL graduated from Mount Holyoke, and maybe I shouldn't say.
We look good, JL.
1962.
Yeah, we look good, don't we?
So we did, I should mention, I'm a graduate of the school, and we have 5 other alumni here who belong to the league, and we even recruited some people from Etna, her fan club there. So I'm really excited to introduce Judy. You can stand and I hope.
Okay.
Yes, please.
Thank you all for coming out on this rainy, miserable day. And I'm going to tell you about the rainy, miserable United States Supreme Court. So it's not too depressing. The Supreme Court, I think, is about to bring an end to a rather remarkable era in American history. An era in which the federal courts saw as their mission the protection of those who were too powerless to protect themselves at the ballot box or in the streets. The period I'm talking about began in the mid-20th century with Brown versus the Board of Education, which held, basically, that segregation by race was a constitutional insult. But since 1976, I say with a colleague I used to teach with that someday we're going to write an article called 1976, because a whole bunch of terrible things happened in his field in 1976, and a whole bunch of terrible things happened in my field in 1976 as well. But since 1976, the court has really eroded that ruling of Brown. And this June, or July, they don't seem too eager to leave yet, when the current term ends, the law of race discrimination as we know it may end as well. In fact, I thought that would happen yesterday, but we dodged a bullet. For a few more days, there are 23 what are called merits cases to be decided on the merits, as opposed to procedures still remaining before the court can adjourn for the summer. They're now going to hand down decisions twice a week, Mondays and Thursdays, so stay tuned. What I want to talk about today is how we got there, how we got to the brink of this precipice. And I'm going to talk about 2 lines of cases, race discrimination and affirmative action cases and voting rights cases, because it's the merger of those 2 lines of cases which the Supreme Court is going to use as a vehicle for all the bad things that I hope, or that I worry that they're going to do. But even more troubling to me than what they're going to do is how they are going to do it. What I mean by that is this. Remember Chief Justice Roberts' confirmation hearings, and they asked him, what do you think the role of a judge is? And he said, well, I'm an umpire. I just call balls and strikes. Despite these protestations of judicial modesty, and his description of himself as only an umpire, I want to suggest to you that this court has given new meaning to the words judicial activism. The critical question in all of these cases, voting rights, race discrimination, affirmative action, is this: whose job is it to ensure racial equality and to protect basic rights like voting? Congress or the courts, which constitutionalists call separation of powers, the federal government, or the states, which constitutional people call federalism. Now, what the Constitution is really about is structure of government. So let's talk a little bit about constitutional structure. Until the Civil War, constitutional rights came from the states. Constitutional lawyers call this state-centered federalism, by which we mean that the source of rights was the state government, not the federal government. The framers, who a friend of mine called the Founding Fathers and the Invisible Mothers, The framers thought of the central government as the danger, and so to that end, the Bill of Rights was directed against the federal legislature. If you pick up the Constitution and read the first 8 amendments, which is the Bill of Rights, it says, Congress shall not. Congress shall not. In fact, it wasn't until the early 20th century that the Bill of Rights applied to the states at all. This began to change after the Civil War with the so-called Reconstruction Amendments, 13, 14, and 15. And the theory underlying those amendments was to federalize civil rights. In other words, to use the Constitution as a federal shield against state interference with the rights of the newly freed slaves. So the 14th and 15th Amendments contain specific prohibitions against the states, and they start out with no state shall. In other words, after the Civil War, the Reconstruction Amendments not only conferred citizenship rights, including the right to vote, on the newly emancipated slaves, but those amendments also specifically authorized Congress, the federal legislature, to enact appropriate legislation. That becomes a key word, appropriate legislation, to guarantee and protect those rights from state interference. But in the next 10 years after the 14th, and so we're now talking late 1880s, early 1890s, the Supreme Court really eviscerated the 14th and 15th Amendments. It limited constitutional claims to claims against the government, which meant that private discriminatory behavior was perfectly constitutional. It held that a corporation is a person for purposes of the Constitution. It limited citizenship rights of the newly freed slaves to the rights of federal citizens, not state citizens. And I've just told you, federal citizenship was a fairly meaningless phrase in those days. And last, as everybody knows, the court infamously defined equality as separate but equal. So all that added together meant there was no constitutional redress when the southern states passed Jim Crow laws denying voting and other citizenship rights to people of color. While the Supreme Court was dismantling Reconstruction, the political alliances behind Reconstruction were also falling apart. And I say this not because I'm an expert on politics, but because it seems to me there's an eerie similarity between what happened then and what is happening today. Today's court is increasingly hostile to federal civil rights legislation. It's increasingly enthralled by its re-envisioning of the states as powerful constitutional players. And the collapse, and on the political side, we see the collapse and polarization of the political alliances behind the civil rights movement. The words of the noted Reconstruction historian C. Vann Woodward are as prescient today as they were when he wrote them in 1955. The political conflicts of whites are being resolved at the expense of blacks. Back to history. Jim Crow as a state of constitutional affairs was pretty much the rule until 1954 with Brown versus the Board. And we're all pretty familiar with that moving story and its transformative idea that it was the job of the federal government and the federal courts to protect people against state laws which discriminated against them because of their race. Brown also stands for a couple of other important propositions which are on shaky footing today. One, since society as a whole is responsible for the long, sad history of racism in this country, society as a whole has the constitutional obligation to fix it. In constitutional law terms, this translates into the rule that when government classifies people by race, it has to come up with a compelling justification for doing so. In other words, I'm going to use legal language now, race-dependent classifications are so inherently suspect that the courts will examine them very strictly. The idea is that discrete and insular minorities, again, magic words, are entitled to extraordinary judicial protection because of their lack of access to the political process. Everybody knows that story. People know less about the sadder story about how the brown right became eroded. The story begins with those cases that, and I'm not at voting rights yet, but all of this has become the law of voting rights today. So the story begins with school desegregation cases, where the brown right to fully integrated schools became integration insofar as practicable. That means white flight. Other cases talked about the fate of innocent victims of discrimination remedies who might lose the advantages that they had enjoyed when people of color were denied access to the labor market. That's affirmative action. Civil rights remedies then were no longer seen as society's obligation, but rather as a punishment of those who had reaped the benefits, the innocent victims, of those who had reaped the benefits of living in a world where jobs were closed to women and people of color. Affirmative action again. And the most serious line of cases redefined the very meaning of discrimination. It was no longer sufficient to look merely to the results of a particular practice, a white male labor force, a white male voting population. In order to question that, plaintiffs had to prove that this was the result of something called racial or gender-biased animus. Animus means hatred. That's not my definition. That's the Supreme Court's definition. And the last thing the Supreme Court did was that it limited the power of Congress to pass appropriate legislation to expand civil rights remedies. The new rule is that remedies have to be congruent and proportional. Nobody knows what that means. To the underlying violation. What does this mean? What this means is that common garden variety race discrimination cases have become affirmative action cases. Why? Well, according to the court, we now live in a post-racial, non-discriminatory world. Since we have magically solved the problems of discrimination, you missed it, but one night while we were all sleeping, we solved those problems. Any consideration of race, same rules for gender, by the way, however minor, will begin a new cycle of discrimination, which is to be constitutionally condemned. Okay, voting rights. For a long time, even after 1976, we thought that voting rights would be immune from these changes. Because the theory of voting was that the more people that voted, the better. Make the circle bigger. In other words, instead of being a zero-sum game, voting was such an important result that we used every attempt to make the circle bigger, to have more and more people given access to the ballot box. The 15th Amendment said that specifically. The right to vote was considered so fundamental that it too triggered strict judicial scrutiny and protection. But the court was not persuaded by these arguments, and over the years, voting rights plaintiffs now had also to prove racial animus in order to win a case. And the court became increasingly concerned. This case troubles me almost more than any of them because it was decided when we were seeing the ethnic cleansing going on in the Balkans. Allowing more people to vote would balkanize, that's Sandra Day O'Connor's language, not mine, the power of existing voters. In other words, if I let you vote, my vote counts for less. That's an enormously backwards and new and different way of looking at voting rights. So this brings me at last to the Voting Rights Act of 1965, which is the case before the court, Shelby County versus Holder. The key is Section 5 of that statute, which provides that any change in the voting laws in certain covered jurisdictions, which are 9 states and parts of 6 others, must be pre-cleared or pre-approved, either by the Department of Justice or the Federal District Court, before they can go into effect. Here's why that's important. Under Section 5, a plaintiff no longer has to prove animus. Instead, the burden is on the state or local government to show that the new laws will not unduly impact voters of color. So I'm sure you all know this, but a brief review of the kinds of voting laws. There are basically 2 kinds of voter suppression laws. One is redistricting, and the other is laws that regulate the process, where the polls are, whether there's early voting, how long the polls are open. Redistricting happens every 10 years after the decennial census, and redistricting for political purposes is perfectly constitutional. But redistricting in order to decrease minority voting participation is not. If Section 5 did not exist, every time a plaintiff of color questioned redistricting, he or she would have to prove that when those commissioners sat there and drew those lines on the maps in magic marker, they did it because they hate black people. Might be true, impossible to prove. Today, at least 30 states have some form of legislation regulating voter qualifications and identification, as well as the time and place when polling places are open. Remember those lines in Florida that we all watched? Again, if there were no Section 5, a plaintiff would have to prove that these laws not only disproportionately affected people of color, but that they were passed because the legislature was motivated by racial animus. Congress first enacted the Voting Rights Act in 1965 in order to deal with the massive and violent suppression of black voters, particularly in the South. As I said before, the heart of the statute is Section 5, and its preclearance requirement. And here's why Congress did it. Although the federal courts in those days regularly struck down discriminatory voting measures, poll taxes, literacy tests, the southern states would quickly find new ways around it. And as we've learned, the judicial process proceeds at a glacial pace. And Congress decided that instead of requiring plaintiffs to go to court state by state, county by county, town by town, water district by water district, it would keep ahead of the game by barring the most flagrant offenders in their voting laws and requiring them to pre-clear any new laws either with the Department of Justice or the federal courts. Again, keep in mind the critical point. The burden of proof is no longer on the plaintiff. It shifts to the government to justify what it's doing. So in 1965, Congress assembled data on the worst offenders, those with the most egregious history of racism, and created a list of covered jurisdictions which would be subject to the preclearance requirement for the next 25 years. That list was amended in 1975 to increase coverage of districts with large populations of what are called linguistic minorities, in other words, the Hispanic Southwestern populations. In 2006, Congress reauthorized Section 5 and locked it in for the next 25 years until 2032. The 2006 did not change the geographic coverage. So the same states that were covered in 1965 with the states that were covered in 2006. This is a critical point. So I need to give you just a little bit more information about what those states are before we talk about Shelby County. Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, Texas, and most of Virginia. The 2006 reauthorization passed the Senate 98-0. Remarkable, right? And the House 390-33. One other point. Covered jurisdictions can opt out of Section 5 by showing a clean voting rights record for the past 10 years. Several jurisdictions, you laughed when I said water district, but this thing applies to every school district, every water district, every sanitation district. Several jurisdictions have successfully opted out. In fact, since 1984, no jurisdiction asking for a bailout has ever been denied. In 2009, the Supreme Court decided a case called Northwest Austin Utility District versus Holder. And I won't say it again, it's the acronym is NAMUNDO, which stands for Northwest Austin Utility District. A small utility district in Texas challenged its inclusion under Section 5 that said, we're just a little utility district, and we don't know from race discrimination, we've never done anything bad, so it's unconstitutional to require us to get pre-cleared when we change the rules of how we operate. And the court ducked that issue on a technicality, said a little bit more grossly, Roberts didn't have the votes quite yet. But he did use the case to share some of his thoughts about race discrimination and about Section 5. And here's what he said. He quoted from the affirmative action cases and said, we no longer need Section 5 because discrimination is over. Quote, the law imposes current burdens and must be justified by current needs. Things have changed in the South. He also said, Section 5 imposes substantial federalism costs. In other words, since we no longer live in a world where race discrimination exists, statutes like Section 5, which purport to address issues of race, cannot be justified because they injure innocent victims. Who are the innocent victims? The southern states and water districts who are still covered by Section 5. The specter of federal overreaching makes Section 5 incredibly constitutionally suspect to this court, which cares mightily about the rights of states to be free from the intrusion of the federal government. Linda Greenhouse, who's my favorite Supreme Court reporter of all time, says the project of the Roberts Court is race. This seems borne out not only by the remarks I read you from NAMUNDO, but by his virtual overruling of Brown versus the board in a series of school desegregation cases in 2007, where there were voluntary school integration plans in Seattle, Washington, and Jefferson County, Kentucky. The rule always was, get your act together, folks, have a voluntary plan and avoid the lawsuit. So that's what these two jurisdictions did. And in those cases, saying that they couldn't do that, Chief Justice Roberts made the now fatuous and infamous observation, the way to end race discrimination is to stop discrimination on the basis of race. A rose is a rose. So not surprisingly, after NAMUNDO and those school cases, everybody lined up to challenge the Voting Rights Act, stressing the Supreme Court's concerns about the undated and unnecessary coverage. And last year the court agreed to, there were about 8 or 9 cases, and last year the court agreed to hear one of them, Shelby County versus Holder. Now, could Congress have avoided these lawsuits by changing the coverage formula and updating it? Probably. But think about that for a minute. Numundo was decided in 2009. The school desegregation cases were decided in 2007. What has characterized our politics since that time? Total partisan gridlock. And so the Democrats in Congress feared, probably rightfully, that any attempt to decide anew which jurisdictions were covered might be so politically dangerous that Congress would not re-up the statute at all. So they decided, you know, hindsight's a wonderful thing. Now everybody's writing PhD theses in statistics about new ways to calculate the coverage formula. We probably would have decided the same thing had we been members of Congress in 2006. Okay, here come the specific technical legal arguments in Shelby County. Some of these were suggested by the lawyers, but two of the more obscure ones were suggested by the Supreme Court. And if that ought to send chills up your spine, wait till you hear what they are. Here's the first one. Congress has no authority to pass Section 5 because the Constitution empowers the states to regulate elections. Not quite true. Article 1, Section 4, Clause 1, the Elections Clause. Quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulations except to the places of choosing senators. In other words, Congress can make rules to ensure that state and local officials do not undermine congressional elections. Justice Scalia prides himself on construing the Constitution with great fidelity to its text and original meaning. Only he knows what the original meaning is. One would hope he would demonstrate that same fidelity to the words of the Constitution, the Election Clause, in Shelby County. The second argument is equally disingenuous. Congress does not have the authority to reenact Section 5 because in so doing, it failed to treat the states equally. This is one of the arguments that the court told the parties they wanted briefed and argued. Numundo says, Section 5 is constitutionally suspect because it, quote, differentiates between states despite our historic tradition that all states enjoy equal sovereignty, whatever that means. That sounds like a good theory. Who could be against equal sovereignty? But it's never been applied in practice. Think about statutes that you know about. Pilot projects, Clean Air Act pollution standards, nuclear waste, Yucca Mountain, responding to individual problems according to the needs of individual states. There's something called the equal footing doctrine if you dig deeply into the case law, but it requires only that states, when they enter the Union, come in on an equal footing with their predecessors. That seems to have to do with things like polygamy in Utah and doesn't really have much to do with voting rights. The third, and this is the most obscure one, also suggested by the court. It's troubling that the court is unearthing all of these constitutional doctrines which are at the back of the book and nobody teaches them anymore. The third argument is that Congress had no authority to reenact Section 5 because it violated something called the Republican Form of Government Clause. That's probably the single most obscure clause in the entire Constitution. And in the bad old days before the 1965 Voting Rights Act, when black voters tried to register in the South, they would say, well, you have to show how smart you are by explaining the meaning of the Republican Form of Government Clause. So it's not only obscure, but for those of us who have read the history of the Civil Rights Movement, it's kind of a little bit racially insulting at the same time. I guess what the court wants to know is, does Section 5 unduly interfere with each state's power to govern itself without federal intrusion? This looks like a nostalgic attempt to go back to the state-centered federalism that we lived under before the Civil War. The last argument is the heart of the case. It says Congress has no authority to enact Section 5 because it is not congruent and proportional, remember those words, to the problem that it was meant to solve. Let the punishment fit the crime. Recall that the Supreme Court now views voting rights cases and discrimination cases as affirmative action cases. During the oral argument, Justice Scalia characterized Section 5 as a perpetuation of racial entitlement. That means affirmative action. In late April, he repeated that in a speech, saying Section 5 is unconstitutional because it's an embedded form of racial preferment. Not only is that insulting, think about the ethics of a sitting judge talking about his opinion on the merits of a case which has not yet been decided. Nonetheless, this argument carries significant constitutional weight, so I want to spend just a minute or two exploring it. What we are really talking about here is separation of powers. Who decides whether pre-clearance is outdated or whether it's still necessary? Congress or the courts? Until the mid-1990s, the balance always tilted in favor of the legislature when Congress was passing laws under the 13th, 14th, and 15th Amendment. But the Rehnquist court started to shift the balance the other way, often substituting its judgment for Congress. But our constitutional system's not supposed to work this way. Before it reenacted Section 5 in 2006, Congress held 21 hearings, listened to 90 witnesses, and compiled 15,000 pages of evidence. The lower federal courts reviewed this and concluded that Congress had shown a continuing need for Section 5. And the Circuit Court of Appeals agreed. Let me read you this quote. The point at which Section 5 strong medicine becomes unnecessary and therefore no longer congruent and proportional turns on several critical considerations, including the pervasiveness of serious racial discrimination and the continued need for Section 5's deterrent effect. These are quintessentially legislative judgments, and Congress, after assembling and analyzing an extensive record, made its decision. Section 5's work is not yet done. After thoroughly scrutinizing the record, and given that overt racial discrimination persists in covered jurisdictions, we are satisfied that Congress's judgment deserves judicial deference. The point is not whether Congress has done a good job or a rational job. The statute books are full of silly laws, outdated laws. Nor is the point whether the justices of the Supreme Court think that Section 5 is still necessary. The point is whether Congress had the constitutional power to decide whether Section 5 was still necessary. And that power is very clear in the plain language of the Elections Clause and the 14th and 15th Amendments. We don't need it anymore is not a constitutional argument. It's a judicial power grab. As Justice Kagan observed during the oral argument in Shelby County, well, that's a big new power you're giving us, that we have the power now to decide whether racial discrimination has been solved. I did not think that fell within our bailiwick. There's a widely accepted doctrine called judicial self-restraint. It's a doctrine loudly praised by those who condemn judicial activism and enthusiastically embraced by Chief Justice Roberts when he likened himself to an umpire calling balls and strikes. Judicial self-restraint says judges should defer to the legislature, except in extraordinary circumstances. Rejecting the 2006 extension of Section 5 ignores Congress entirely. And it would also suggest that Congress lacks the power to redress all kinds of discrimination, not just in voting rights. Justice Scalia's intimation to the contrary during the oral argument was even more insulting. Members of Congress are afraid to vote against civil rights laws, and therefore this is, quote, not the kind of question you can leave to Congress. That's offense. That's not my language. That's his. It's been reported in all the newspapers, and it's in the transcript. This is offensive at best and constitutionally terrifying at worst. The arguments about Section 5 have been filled with lovely platitudes about how the re-election of Barack Obama is issued in a new halcyon post-racial age. Pious pronouncements of this sort perpetuate romantic and cherished myths about equality. They also ignore reality, perpetuate the status quo, and fail to protect the powerless. A world without Section 5 would be a world without the crown jewel of the civil rights movement. Thank you.
I think we heard in both barrels.
Well,
That was fascinating. I don't think you should stand anymore, but there are questions.
sure. Yeah.
When are we likely to hear this decision on Shelby County? This week, maybe?
Maybe, before July 4th for sure. I
Okay.
went back and looked, the latest I could ever find, my recent memory of them sitting was July 15th.
Oh,
They tend to save the most controversial ones to the very end and then they get out of Dodge.
well, those robes are hot.
Yeah, and they've got affirmative action, they've got this voting rights case, they've got the Arizona misinterpretation of the motor voter law, they've got the Defensive Marriage Act, and the California gay marriage case. They've got 23 undecided cases, but they've got those 5 hot potatoes. So I'm betting that they'll be the last. But I don't know anything. I mean, I'm just betting. Yeah.
Aside from death or resignation, is there any other process to get rid of a Supreme Court member?
There is impeachment.
You can't impeach
Oh,
them.
you can impeach. But you can only impeach for, quote, high crimes and misdemeanors. That means hand in the till. There are a few impeachment of lower federal court judges, and they've been hand in the till in dozens of cases.
The
There are-
till could easily be defined in my mind as my life.
Well, that's true. There are some, Congress, federal courts are set up by Article 3 of the Constitution, and Congress has the authority to make rules for Article 3 courts, so they can change their jurisdiction. They could mandate a retirement age. So there are things, they could expand the number of Supreme Court judges. It's only been 9 for the last 100 years. Before that, it was up and down and up and down. So there are things like that that Congress could do. Are they going to do it? No.
They can't vote to get time to go to the bathroom anymore.
You got it. You got it. Yeah.
Do you have any feel on, in terms of this court, on which justices are gonna, there's a swing justice, right?
Kennedy.
Do you have any sense of,
I read the oral argument. You can too, it's online. Read the transcript of the oral argument. I don't like the questions that Justice Kennedy was asking. Sometimes they try and be kind of cute and ask questions to mislead you about where they're coming from. Kennedy's not too cute, typically, and the questions he asked lead me to believe. He's the one that came up with the Republican form of government clause and the states being treated equally and required those issues to be included in the briefs. So that makes me pessimistic about how Kennedy's going to come out. On the other hand, he loves being the swing justice and being wouldn't you? And being courted by everybody. So there's a chance that he might try and cut the baby in half, but we'll see. I'm really pessimistic. Based on the earlier cases that I told you about, they almost did this in Namundo, and Roberts didn't have the votes. O'Connor left, Alito came on, he's got the votes now. So, I think we're gonna lose, I think we're gonna lose big.
Do you have any sense of what kind or how much intensity of comment and concern is on the web?
I read a couple of favorite blogs and a couple of, there's a law school thing called Prof's blog, and the best one is called SCOTUS blog. I don't read widely on the web. Maybe what you're suggesting is, can we influence the court somehow? There's a theory that Roberts is terribly concerned about his legacy, and that's why he voted the way he did in the healthcare case. I think healthcare was a major loss because he said that Congress no longer had authority to pass laws under the Commerce power, which is 99% of congressional authority to pass laws. And what he said, you can pass laws if you make it a tax. Can you see this Congress saying, we hereby pass a new tax to be called the vaccination protection? They're not going to do it. So that says to me that he claims to be concerned about his legacy, but I wish I understood the psychology. I wish I was a psychologist and not a lawyer.
We just don't know what he wants, the legacy.
I think he has an agenda, and if you read what he wrote below before he came on the Supreme Court, I was teaching in the Iliad program when his nomination was going through the Senate, and many of the students said, oh, phew, we dodged, Harriet Myers or whatever other people were before him. He's okay, he looks like us, he talks like us, smart, dresses like us. I said, read what he's written, he's the most dangerous one of all. He was in the Justice Department under Reagan. He wrote all kinds of things. I mean, you gotta do your work. Chief Justice Rehnquist wrote a draft opinion dissenting in Brown versus the board when he was a law clerk on the Supreme Court, saying segregation is okay, don't overrule Plessy. I mean, imagine if people had found that and talked about that, maybe, when he was being nominated. So it's all there. Yeah.
This, to me, has a lot to do with voting, although not on the topic that you were discussing, and that is the Citizens United decision.
Yep.
Which I'm not very knowledgeable in these areas, but even I, when that was passed, or the decision was handed down, I was just appalled. And is there any hope that at any time that could ever be overturned or regulated or something?
Slim to none. The obvious way to do it is to rewrite the Constitution. That's a non-starter. The constitutional amendment, remember the ERA, the constitutional amendment process is hugely expensive and time-consuming. And the press has said that they will oppose any attempt to rewrite the First Amendment. So that's a non-starter. Citizens United leaves open the Justice Kennedy says, well, I don't know what you're so worried about. We'll just have everybody disclose. Go pass a disclosure law, Congress. Dead silence. Not very much. And people much smarter than I have been scratching their heads trying to write a statute to get around Citizens United, and they can't figure out how to do it. And I sure can't figure out how to do it.
But what were they thinking? What were they thinking?
Corporate America rules the world. That's what they've been thinking. That's of a piece of what they have been doing for the past 10 years. Corporation is a person with the identical, even Rehnquist said, yeah, corporation's a person, but to give a corporation those kinds of First Amendment rights is ludicrous.
But now it's been done.
Once you say they have the same constitutional rights as you and I, that means preserving the existing corporate oligarchy is what they're about. I mean, I know I sound like Eugene Debs or somebody, but it's hard to avoid that conclusion.
So how do we change that?
I don't know how you change that. Well, I've got some thoughts. I used to be a bomb thrower, now I'm an incremental radical because I'm old. I think you start by appointing judges to the lower federal courts. The Democrats are terrible at it. The Republicans are brilliant at it. Since Reagan, they have made it their priority. So that it depends on who you read, but it's 80-something% now of the judges in the lower federal courts have been appointed by Republican administrations pursuant to an ideological litmus test on race, abortion, campaign finance. Obama has not been good at this. As a matter of fact, he's been terrible.
They've been blocked by the Senate.
Yeah,
I
but
mean, you
he
can't
needs
get
to-
For 2 years, he had a veto-proof majority, a filibuster-proof majority, and he isn't even sending names up. There are now 85 vacancies. There were 115 when he started. Sometimes constitutional law percolates up from the lower courts. We all get all exercised and we march and we write letters when it's time for Supreme Court appointments. But sometimes I think we've totally missed the ball on that one. That's not a great solution. It's a little more than a timid first step, but it is a first step. Yeah.
Those justices you're talking about, that, you know, in the lower courts, is that part of this whole business about, I guess, quote, Republicans or conservatives making a concerted effort since the Reagan era to get people, not only the courts, but to get people trained in law schools that had a bent toward that side of the argument?
You know, that sounds awfully conspiratorial, but I suspect you're right. I don't know that,
You look at the front.
but I think so. I think so.
Could you say a few words about the Arizona case? I know this is
Okay.
complicated, but it's very dear to the league because it involves registration of voters.
So the motor voter law was a statute that tried to make it easier for people to register to vote. When you register a car, you'll go and register to vote. You don't have to make a separate trip. And one of the voter suppression techniques that state legislatures are using is when you go to register to vote, they're going to require all kinds of things. And Arizona, I have it written down somewhere, I think it's a government-signed photo ID and proof of citizenship. So there are two questions in that case. Does the Federal Election Clause say that and the Supremacy Clause say federal law trumps that, so you can't go make federal rules that conflict with the state laws? And then there's a very technical argument turning on such things as the difference between may and shall and can and cannot, which are technical ways to get rid of the Arizona statute as poorly drafted to avoid the constitutional question. They haven't decided that yet. But the oral argument was all about the technical stuff. It was not about the Constitution, which is interesting. So maybe they don't want to take it on as a constitutional matter, but who knows? We live in Arizona, my husband and I, in the winter. It's a crazy place. I mean, it's really a crazy place. The state is bankrupt, and all the legislature does is three things. One, more restrictions on abortion. Two, more restrictions on voting. And three, more places where you can take a loaded gun without a license. You can now take a loaded gun into a bar in Arizona without a license and without a concealed carry permit.
You realize that sounds a lot like New Hampshire.
Oh, I do. We get back here and we think, well, here we are. You know, we lived for years in the